Hello friends, how are you? Today I am going to discuss an important perspective concerning the Prevention of Corruption Act. Friends, when we get acquitted in a case under the Prevention of Corruption Act, the state usually files an appeal before the High Court because it is the basic right of the state or of the defense to make an appeal before the higher court if they are not satisfied with the judgment passed by the concerned trial court. Friends, when the appeal is filed before the concerned higher court, it is usually contested on the merits. The merits may be the grounds of facts or the ground of law. And there is one of the important point which is usually ignored by us, which is the ground of limitation. Friend, this ground is very much important as far as defense is concerned, because if the appeal is filed and the ground of limitation is raised and if it is successfully accepted by the concerned court, in that scenario, the appeal will be rejected without considering on the merits. So this is one of the better point, this is one of the best point as far as the defense is concerned. Friend, in this case which I am going to discuss with you, the concerned High Court rejected the appeal of the state on the ground that it is barred by the limitation. But it was not a very easy task. You have to raise this point systematically, you have to raise this perspective in the right manner so that the court could be convinced and fruitful results could be accorded in your favor. Friends, in that case, a FIR has been registered under section 420, section 465, 468, 471 of the IPC. Read with section 13(1)(d), 13(2) of the Prevention of Corruption Act. The matter in nutshell was that allegations were raised against the accused person that by having hand in glove, they first committed the forgery for the purpose of cheating, and while misusing the official position, they have misappropriated the amount or the funds that was allocated by the state government from time to time. Subsequently, charge sheet was filed, the trial began, and ultimately the accused persons were acquitted from the concerned trial court on the ground that the prosecution failed to prove the case beyond the reasonable doubt. Being dissatisfied, the concerned state has filed the appeal before the concerned High Court. When the concerned accused persons had received the memo of appeal, but rather to challenge the same on the ground of contest, they have submitted that the appeal is barred by the limitation on the ground that there is a great delay, it is unexplained and could not be condoned in the easy manner. Rather, to answer the concerned contentions raised by the defense, the prosecution merely submits, Your Honor, that there is a delay. And delay is justified and it is totally explainable. What they have submitted, that the judgment was obtained with a delay. Subsequent to this, file was sent to the concerned department. Then the comments was received. Then it was sent to the final authority for the final approval. And after that, the appeal was filed and the delay is justified and the appeal should be admitted and should be heard on the merit. And the important point that was raised by them is that, please note down, I am going to narrate, making a justice-oriented approach. From this perspective, there was a sufficient cause for condoning the delay in the institution of the appeal. So, the state tried its best to convince the court that the court should adopt the lenient approach while accepting the contention, because in section 5 of the Limitation Act, it is mentioned that the cause should be sufficient. And once the sufficient cause is shown, the court, while adopting the lenient approach, should admit the appeal and should condone the delay. But in the present case at hand, the concerned defense had raised the counter-attack. What was the counter-attack? The Doctrine of Equality. Please note down the Doctrine of Equality, which says that the law demands that all the litigants, means any person, any accused, any state, if going to the concerned court as a litigant, they must have the same treatment as accorded to every person in equal-handed manner. It means when there is a delay on the part of the accused, the state opposes that the lenient approach should not be adopted. On the contrary, when the state is making a delay and they are praying that the lenient approach should be adopted, it means they are not having any respect for the Doctrine of Equality, which says that the equal treatment. And while considering all the perspective, the concerned court held that whatever reason accorded by the state is totally unimpressed, is totally unjustified, and even they are not able to put any contention before the court that why delayed was made. In that scenario, the delay was not condoned and ultimately the appeal was rejected while considering the contention and the law laid down by the Honorable Supreme Court. So friends, if you are having the same issue, you could be benefited with the same protocol. Just have a belief in the God. Just fight your case on the ground of limitation if the set point is involved in your case, rather than to contest your case on the merits. So if this video is beneficial for you, just share it. See you in the next topic. Have a nice day. Jai Hind, Jai Bharat.